All right. Welcome everyone back to another episode of Finding Your HR Advocacy Voice. Now, please excuse my area here having technical difficulties, but when you're going live and you love what you do, you just make it happen. And so that's what we're going to do today. So we are so excited. Of course, we have Chris, my co-host, the HR pro. And then today we also have Rachel Guin, who's also joining us. Not only she'll talk more about herself, but she is also the government director of government affairs for NIHRA. But remember, as you've seen our disclaimer, we're just having a great time having conversations and just sharing what we know and just making sure that we're educating as best as we can. But of course, don't hold us liable to anything. So, Rachel, welcome to the podcast. Tell us a little bit about yourself.
Absolutely. Thank you so much for having me. So Rachel Guin, I am a partner at Rothberg Law Firm. I have been practicing law for well over 10 years now. And before I was an attorney, I was a paralegal. So been doing this most of my life in some capacity. And I, in addition to being a lawyer, I also serve as the president of the board of directors for both our ambulance authority here in Fort Wayne and our Fort Wayne Fire Merit Commission. I'm also the president of the board of directors for Blessings in a Backpack, which is an organization that provides food to children over the weekends. Very proud of that. It's an important mission of mine. And then I sit on the NIHRA board, as we discussed. I represent private companies and government in varying capacities. One of my largest clients is our public transportation system here in Fort Wayne, as well as in Bloomington. So I've got clients across the state of Indiana, Illinois, Ohio, Kentucky, and I stay busy. So, but most of what I do when I'm practicing law is employment and labor. I help people write policies, work through difficult questions, and hopefully give them advice that probably isn't always legal advice, but best practice advice more often than not, so that they can be successful as leaders themselves. So yeah, a little bit about me. Thanks for having me.
Oh yeah, that is awesome. No, I love that. Chris, did you have anything that you want to say? Because I know I felt like
No. I'm just excited to have Rachel on, and I think it's great to have her with us.
yes, definitely for sure. And then especially with that resume, yes, definitely, it's just across the board for sure. And so with finding your HR advocacy voice, one of the things that I just want to throw out there is that we know that sometimes policy and legislation kind of rubs people the wrong way sometimes, or people run the other way. They get scared when you say, hey, come on, let's have a advocacy conversation. But one thing that we always want to really emphasize is that it's really not about politics, it's about policy. But we understand that politics does help facilitate the process, but we definitely don't wear a jersey, like Chris will always say. And so I just kind of wanted to start off with that. So what has been going on? Like, Rachel, from your perspective, what are some of the things that you've been seeing happening here at the state level, considering Governor Braun, and this is his first term, and the Indiana General Assembly session just ended April 29th. What are your thoughts?
Yeah, I mean, I think there's been so much focus on SB1 for local government, right? I mean, that's just, we're still talking about it and trying to unravel this monstrosity of a document and understand how it's going to impact all of local government. But there are a lot of other things were happening while SB1 was being argued, and they didn't get as much press. But I do think they're extremely important, particularly for this conversation. And one of those is the Parent and Childbirth Recovery Leave Executive Order. Yes. And that's something that it's EO 2534. Governor Braun implemented this very quickly into his tenure, and it offers 6 to 8 weeks of paid leave to mothers. The 6 to 8 is depending on whether it's a vaginal delivery or C-section, and also eligible to women experiencing a miscarriage after 20 weeks. This is not something that I heard Governor Braun run on when when his campaign was going. But I, as a woman and a mother, I was like, wow, where did that come from? This is exciting and also very impactful. Now, this is just for state employees right now, but it sends a message to the rest of the employers across the state. And I think you'll find in other states, typically blue states, who have similar benefits for their employees, employers within their states start to follow their lead, and they see the benefits of something like this, how it can attract talent, keep talent, and so it's really impactful. I think I'm excited to see what the long-term impact of this is across the state of Indiana, and in particular with private businesses. So, one of the other things we had something called the new parent leave law that Governor Holcomb had put into effect, and that offered 150 or 75 hours of paid leave, depending if you were full-time or part-time, and you were eligible for that after 6 months of employment. And Governor Braun's executive order took away the barrier of that 6 months of employment. So now you not only get that 6 to 8 weeks, you also get the 150 or 75 hours, and it starts on day one. So, there's a kind of, I wouldn't call it a restriction, but if you are not 6 months into your employment, you do have to offer a guarantee that you'll remain employed concurrently for a period of a year after. And I don't know that they've worked out all the kinks on what that looks like if they don't, but there are ways to maneuver through that. And then, of course, all of these leaves run concurrent with FMLA. But it at the end of the day, female employees of the state now get 10 to 12 weeks of paid leave, which is really more progressive than some other states that we would consider more liberal. And so, again, I haven't heard a lot about this in the media, but I think it's exciting. So,
no, I love that. Now, Chris, anything that you want to share with that? Because I had a question.
No, I was equally surprised. Right, you're absolutely correct. Right, he didn't campaign on that. There was never a word of that came up. Any legislation that's even halfway looked like that in past years has never gotten out of committee. There was a bill that Governor Holcomb's office, Governor Holcomb championed, and that's what Tracy I was talking about. I think it was like 2 or 3 years ago, where he, as folks here know, I represent the state council on the labor law policy committees at the Indiana Chamber, and I'm the chair of the healthcare policy committee. And Governor Holcomb's office was working with the labor law committee on a bill around what was really accommodation, right, for pregnant females.
Pregnancy,
and,
yes.
Yeah, and we were working really well together. Thought we were. The governor's office was meeting with us pretty regularly over the summer, and then the last minute, they decided to stop working with us and went with their own bill, which we couldn't support. It ran so it ran a direct conflict with the ADA and most of the other accommodation stuff that went on. And even though we told them that at the outset, we said, look, these are the actual conflicts with the law. You got to eliminate those. And they didn't want to do it. And then they found somebody to carry the bill, and then they ran it to a committee it didn't have any business in being, largely because the chair of the committee where it should have gone wouldn't hear it. And so I testified against that bill. Chamber testified against the bill. A couple of other outfits did. And it ended up getting routed to the correct committee in the House, where it wasn't heard and died. And then the following year, the Chamber got behind legislation that we could live with, and eventually passed that. But that was not anywhere related to this EO. I mean, because this deals with compensation and leave simultaneously.
And the new leave from last time that Rachel was talking about, is that related to that same policy that you're talking about?
No. I mean, this has been any bill. I want to emphasize, any bill that's even breathed anything even close to what this EO states hasn't seen the light of day before a committee ever. And I project would not. I can't. Knowing those committee chairs, I can't see them willing to put that kind of mandate on employers.
That's interesting. So I wonder, so would we, from your perspective, Rachel and Chris, would you say that this policy is something that's new to the state of Indiana? Because I guess, because I had, okay,
Oh,
because
yeah.
we had a paid parental leave, but very
Oh, make
interesting.
no mistake, this leaves California in the dust.
Yeah, that's what I was. I
Oh.
mean, it is.
Sorry, I didn't mean to stump that.
No,
I'm just trying to answer
that's
Tracy's
perfect.
question.
No,
I
but
mean,
that's
Yeah.
perfect. That helps me. You know how I need that kind of help, Chris.
Well, what we did have, Tracy, and this was going back to 2018, and I didn't know about it until I started looking into this executive order, which is surprising, but still limited to state employees,
Right.
was that 150 hours of paid leave after 6 months of employment and so on and so forth. So this just really expands on that. And like I said, now we're at 10 to 12 weeks. So, I mean, if you have a cesarean section, you get 12 weeks of paid leave off as a state employee right now. And that's more than you're going to get in the private sector, even if you've got like short-term disability, unless you've got a doctor's note expanding a need for special care. I mean, even typically under the FMLA, you're looking at about 8 weeks as a standard on that. So I think it's very exciting. To Chris's point, it's so much more than what we see in other states where we would expect this kind of thing. So,
and it really does. I mean, I understand. It makes sense to me politically in this sense. It is very likely that the governor trims the size of the state government employment base over some time. Now, he doesn't have a lot of running room to make because Mitch Daniels and Governor Holcomb kind of beat him to that. So there's not a lot left, right, to cut. But nonetheless, I think he will. And the
to pay for that, to help pay.
No. I think that's what's coming. And the majority of the workforce of the state in Indiana, just like most states, is female. That's the majority of the workforce in the public sector, right?
Okay.
That's the majority, and so I just think it's good politics. If you think you're going to do that and you're going to rile people up, well, I would come running out with something that was very supportive right off the bat to make that to help blunt that argument. But Rachel's right. I mean, total left field. Like didn't talk, didn't breathe, said nothing. When I had the same reaction you did, Rachel. I saw the EO. I was like, what?
Yeah. I was like, wait, who signed this?
Yeah, very much so.
Yeah.
So then I'm curious about how does something like this get paid or funded?
Tax dollars.
Yeah.
I mean,
dollars, okay.
Which is why I feel pretty comfortable his pay
That
for
they're going to he's going to cut, and that's why I figured that's why you were saying.
I feel pretty comfortable that's what's coming.
The work,
there's going to be a pay for. Yeah.
And all of his executive orders, at least all of them that I've looked at, are very thoughtful. I want to give him credit for that, including this one, because it talks about the importance of that initial bonding time with the baby, the health benefits to both the mother and the child, the reduction of stress on the family, not having to worry about the loss of income. And there are some statistics cited within it as well. And so it's well done. It's well thought out. And I'm assuming if he feels as though he's going to have to argue against it, he's built the argument within the EO already to justify it. And he's done that in a couple others that are, again, extremely impressive. The one, I don't know if you're ready to transition, but,
okay, go ahead.
Oh, go ahead. Yeah, no, go ahead.
Well, before we transition, I was going to ask a question about, what kind of pressure would that put on private employers? Like, what does that look like? How could that, transition over to private employers?
I'd say it's capitalism at its finest, right? So you're competing with the state now to be a great employer. And one of the things that private employers often have are better wages. When you're a public servant, you aren't going to be making as much. But heck, if you're planning on having children, this is a huge benefit to you. And so you may be willing to take less pay, knowing that you're going to have this time off to be with your family.
Yeah.
So definitely,
I concur. I think it gives them leverage. there's always a bill. Well, there wasn't. I shouldn't say there was always, because there wasn't this year. But I could easily see the a Democrat in the Senate and the House, maybe even more than that, offering almost an identical bill in the next session. I would expect to see, as a matter of fact.
Why?
I just can't see the chairs of those two committees where those bills would go, given the time of day, because they're just so reluctant to mandate employers do something to that level.
Oh, okay, that's what you mean. You mean there could possibly be a bill
Yeah.
that
Plus,
mandates
our policy
yes,
peg, right?
okay,
At the state
well,
council, a one size fits all thing for employers, and a mandate like that
Right. Well,
is a non-starter with us. We're hard opposed on those, right?
Yeah, keeping in mind, we have no paid leave requirements. I mean, you don't have to offer your employees 1 day off of paid leave. You don't even have, and I get this question a lot. Your employees in the state of Indiana, they have no right to a break. Arguably, you can say you have to
none.
36.
The only language really speaks to lunch, to a meal.
Nothing.
I mean,
nothing.
Oh my
it's a horrible business practice, and no one does it. But you can actually mandate your employees to work 36 hours straight and fire them for not doing it. I mean, that's the state where we live. So for this to be, where it's at, it's pretty.
Yes. Thank you for the contrast. That really helps for sure.
Yeah. What I've always said when I testify, when these kind of bills come up, I always make it very clear. What we're opposing are the mandate components of the bill. Now, if you ask me as an HR pro, do I think this would make good sense for a company under certain circumstances who wanted to position itself in the marketplace in a certain way, who wanted to do sort of things? Go get it.
Yeah.
Go get it. But there's also no law preventing that right now.
No.
So nobody's stopped from doing anything. So I always make it very clear. It's don't mistake the opposition coming. If you ask me if it makes sense, it could be a good idea for different sort of employers. I could easily tell you I've got some clients that I think could benefit. They don't go for it, but But yeah, if you're gonna shove it down everybody's throats, then no, we're gonna oppose.
Well, yeah, I can definitely see the business community, fighting back as well. If something like
that's what I said. Those chairs are not going to shove themselves in the buzzsaw of the Indiana Chamber on. No, they wouldn't get it.
Okay.
And for more context, just Kentucky has leave law. I mean, they have break laws, right? And then Michigan and Illinois, when we're looking at our neighbors, have paid leave. It's not substantial, but it is across the board for everyone. Ohio is our most similarly situated nearby counterpart with none of the break laws, none of the leave laws. But Kentucky's even got some break laws. So,
That is hilarious. No, that is funny. I mean, working 36 hours straight. Yeah, I mean, for sure. But
Rachel's absolutely correct. That point you made that nobody does that.
Yeah, well,
you could, but nobody.
The word complex would be. I mean, it would be a terrible idea.
And that's what's interesting about all these legislation is that sometimes we don't realize that there's so many old laws that that we don't currently use. But it's still there.
We never do away with them.
Yeah, so that's
it's still illegal to hitch your horse in front of the state capitol.
Yes, because that's what we talked about that one time. Yeah, who has a horse? But I mean, in some areas they probably could have a horse. So let me take that back, right?
The lack of the hitching post would probably be the dead giveaway, but yeah.
So Rachel, what else are you seeing? At the state level?
In speaking about a surprise. As well as something that was really well done. Executive Order 2546, which is titled Improving Opportunity and Reducing Recidivism by Improving the Path for Reentry. It's very wordy within the Department of Corrections. And so, again, I took a step back and was like, wait a second. And this is, I mean, he's absolutely right. This is a problem. We have, I don't know how many hundreds of thousands of people in prison throughout the state of Indiana, including our federal prisons, and we release them without the tools to be successful. And so, and I know I can speak for the city of Fort Wayne, we have, because we have so many resources for the unhoused and we have a reentry program here, they're giving bus tickets when homeless people get out of jail, like in South Bend, and telling them to come to Fort Wayne. And so now we've got a bigger problem here.
Yeah.
And because of the resources that are there.
Same thing with the homeless population. They get bused. We get in Bloomington, we get 6 counties worth of people.
Oh, I don't know.
Oh yeah, sheriffs will drop them off right at city limits and turn around and go.
What?
Oh yeah.
Okay. Okay. Whoa. Okay. Go
They
ahead.
don't have any programs for them, and Bloomington kind of does.
It's a great city. In his EO, again, he goes through and talks about the recidivism rates. And so, recidivism rate of 52% over 3 years for people who are unable to maintain employment. Alternatively, for people who are able to maintain employment, recidivism rates drop to 16%. And so what he's required is for the commissioner of the IDOC to kind of not necessarily fix the problem, but to create some initiatives to help these people gain the tools that they need, whether that's skill sets, education. And then one of the initiatives is to provide family reunification skills, which I thought was
bringing families together and helping them, reacclimate. And
then work with community partners to provide safe and stable housing, and also businesses establishing accessible employment pathways. And this was something he talked about but didn't do formally, but it was also to reduce barriers for convicted felons as they're going into the workforce. So I was expecting an EO on that, but I didn't see that. But it's part of the conversation, and he has said, just because somebody got a DUI 15 years ago or whatever, and as a felon, should that really be a barrier for them to have a job that hasn't, doesn't have any,
doesn't involve driving.
Yeah. Thanks for saving me.
But that goes right. Yeah. That's right with the green rules, right?
Yeah. Yes. And
the green rules, what are the green rules?
Go ahead.
Go ahead. Right now, Rachel, you go ahead.
Well, there's a state, this is something that's already been in existence, which is a state law. So and it's for the executive branch specifically, if you're applying for a job in the executive branch, your criminal history will not be held against you unless the crime itself is specifically say a crime of theft and you're going into a job of finance or certain violent crimes. So this exists or existed just at the executive level, but now it hasn't formally been expanded to the rest of the state. Instead, what he's doing is he's saying, I want you, Department of Corrections, to look into this. And there's reporting requirements. I want you to come back, tell me what you've come up with, and tell me how we're going to fix this. And when you're engaging with these community partners, I want you to also tell me who is willing to work with us on this. And then he's publicly saying, we need to reduce these barriers. And also in his other executive order, when he's talking about reducing barriers for, education that's really not applicable to the job, do you really need a bachelor's degree to do some of these things? He's also saying to the state, when we're looking at these crimes, if you're prohibiting someone from getting the job because of a crime, it better be again something that is legitimately prohibitive for that job.
So Tracy, what I was referring to was the broader EEOC guidance, right? And this goes back like, oh my gosh, 8-10 years now. But with the EEOC, basically, because they did a whole deep dive into this, EEOC did, and looked at the use of criminal background checks, right? As barriers for recidivism. And what they found is that there were real good reasons to do criminal background checks. So they said the employers are actually doing it. But they also acknowledged that the impact was pretty severe, especially because of the high percentage of Black males in the justice system, right? So there's a disproportionately high percentage there. And so they said, okay, you're doing this, but it also has a disproportionate effect. And so what came out of that was, look, you can't just blanket exclude from consideration, just nuke the application. Don't even consider them if they have a conviction for anything, right? So he said, number one, you can't do that. Number two, if you're going to exclude him, it's got to be relevant to the job you have. So Rachel used, DUI. Well, I used to see that all the time, right? When I was working for other people, and I was hiring for inside sales. And so if somebody said, they had DUIs, I'm like, well, if they're just driving to work, that's not on me. And I'm not asking to drive. They're selling from a desk.
Mm-hmm.
I don't care.
And I'm sorry, because I hadn't heard that referred to as green laws, but that
green rules.
Okay.
Rules. Yeah. And that was out of one of the cases that EEOC had litigated. I think it went back to dollar stores. I think the plaintiff was Green, and then I think dollar stores was the plaintiff.
Okay.
They were just, because dollar stores would get like 8,000 applications, and so they just told. And they only have 2 employees in the store, right? So they were telling their managers, okay, we got to cut through this stack. So anybody that checked the box, nuke them. Well, so that's what kind of drove the EEOC to that guidance, right? So they were like, you can't do that. It's got to be relevant, and you have to look at the passage of time. So if they committed, if they had a crime here and it's been 30 years and nothing ever since. So they said you had to take all of that account. So you couldn't just exclude. You had to apply a few tests here to determine that. And so the guidance I always give to my clients, and the guidance I've always given to HR professionals is you don't pay attention to that. And the ones that are hardest to climb past, bluntly, are the felony convictions for aggravated assault, rape, stuff like that.
Yeah.
Now you're really putting yourself in peril.
Putting people in the workplace.
Anything goes sideways.
Yeah, definitely.
You're going to have a hard time.
Yeah, and those
are the hardest. Those are the hardest. Yeah.
They are, and that's it comes down to like that disparate impact concept. But the courts weren't willing to make that the law of the land and prohibit that.
Right. That's why I said guidance.
Yeah. But they have done it in other situations where, for example, there were height restrictions for becoming a Department of Corrections officer. And it essentially prohibited women from being corrections officers. And so that instance they said that was arbitrary to their ability to be able to do the job, just kind of creating some contrast between the two situations. But in the Green case, that decision, they said, wait, we're not really ready to go this far because there are plenty of circumstances where, unlike your height, where the crime you've committed is applicable. But it is one of those situations where other states have taken the position that the EEOC took, and they have removed those barriers, and not hiring because someone has been convicted of a crime is an unlawful discriminatory practice in those states. So, and that's not always clear to people, and my clients in Indiana, I get that question.
I would agree. Yeah, I would agree. And and Rachel's done a great job of pointing out the distinction between something being codified, and I'm talking about something being guidance. So I've always advised, when the EEOC gives you guidance, they're telling you what they're going to do if you don't do that.
Yes.
And I always say, you never want to be on the other side of the EEOC. When they clearly say, hey, we're giving you guidance, they're basically saying, if you don't do it and we catch you, we're coming. That's in essence what it is.
And they're doing a lot of that right now. I know I didn't plan on transitioning to that right now or in this conversation, but go ahead, because they've done a complete about face, right? The EEOC. I was at a public transit conference, a room of 160 lawyers. While we're sitting there, we found out that 20 of the big law firms got letters. Accusing them of stating that
basically ask them to report.
Yeah. And so, and then they were said, but very aggressively, we're coming to investigate. So we want to
Yes,
know what
they
you
did.
got. And so everybody's like, oh God, looking around the room, like who's in here that's on this list.
And that was referring to, and what situation is that really? Was that
That's
like
the
the
new
DEI?
commissioner. She's referring to the new commissioner. You and I talked about this on the last
Yeah.
Oh, okay.
So is it like the DEI though? Is that what?
Yeah.
What? Okay, for that. Okay.
Yeah,
Okay.
and it was focused, and her adjectives around selection.
Well,
What was her adjectives around selection?
The focus of this was their application of DEI objectives as it applied to employee selection.
Oh, okay. Okay. So it's specifically relating to that.
She was focused. I'm
Yeah.
saying she was focused on that, but
On
that's
that.
consistent
Okay.
because she's been this way since law school.
Well,
So-
yeah, and then we did talk about that on the
I said you just got to go back and look at her. When she was editor of the law review at UVA. She's thought this was running afoul of Civil Rights Act from jump. So I'm
interesting though to see the difference, Chris. And I know we don't have enough time to really delve into this, but I'd love to know more about your thoughts on it, because this is the second time she's held that position. But what she's done, now already very quickly, it obviously gives us insight into the authority that she's been giving. And so I didn't know or don't know whether that's really her doing it or that's coming from the executive branch. And it's probably a little both based on.
I was going to say, I think they're entirely copacetic.
Yeah.
And now, and this is a good segue because now they've now they've got the majority on the commission. So I expect to see a whole raft of guidance coming out in weeks on a whole host of initiatives around DEI.
So interesting thing that was told to me by someone with the Department of Transportation. She was from Washington visiting for the public transit conference. And they basically said, they normally give a presentation, or the FTA. I'm sorry, I said it's the FTA. So, so we said, oh yeah, we're looking forward to seeing your presentation. She said, there is no presentation. And I was like, oh, where's your team? There is no team. Oh, okay. She said, yeah, we will not be making any comments because we have nothing to say. Okay.
Oh,
so 2 days in, the one comment she did make was that do not expect guidance from us because the new rule is if you implement a new rule, you must pull back 10. And she said to their understanding, and this was about 6 weeks ago, guidance was considered a rule. Now, does that apply to every agency? I don't know.
Yeah, hard to tell.
I know.
Oh, wow.
I don't know that that's the law of the land, but that was her perspective, and she's fairly high ranking in.
Yeah. So and that's part and parcel. This is actually kind of consistent with President Trump's first term, where the kind of the thinking around the point you made, Tracy, that old law never goes away. And so one of the animating perceptions, I think, of the administration, and again, I reiterate, this goes all the way back to the first term for the first presidency, that the people, the citizens, the companies, you name it, all of them are overburdened with too much law, and just because we haven't cleared the decks on stuff that's old and that's a fair concern, right? We know I've never seen the legislature go back and say, hey, we really need to clean things up from 1910. We just never got around to that.
But this can create the opportunity for that if you're able to go back.
You've heard now, and you've heard me say this before, Tracy, this is one of the challenges with trying to do things wielding law, because law is a blunt instrument.
Yes.
That's why I say all the time, I was like, employers need to get into action and do the stuff that makes sense, because if you leave it to the legislature, they're going to write a piece of legislation that is not one size fits all. Chances are it's ugly as the day is long, and it's going to be blunt because they've only got one tool. It's a hammer, and this is a nail. And
they think they're trying to be helpful, but
and so you end up with what you said, right? You're exactly correct. If you're going to put one in, pull 10 out. That's blunt as it gets.
So
see what I mean? It's not wieldly.
Yeah, and in one of the things, I mean, one of the biggest conflicts that we see, and I know there are a couple cases pending that I'm sure will end up in front of the Supreme Court soon, is the potential overturning of Bostock with the EEOC's guidance. They are right now, they are no longer investigating, and apologize if you guys have already discussed this, but any LGBTQ related allegations of discrimination. So as the charges still statutorily must be filed, they're flowing in, and then the EEOC is just issuing the notice of right to sue. So no attention is being given to it. And so, and I think a lot of people initially thought this would be focused on transgender because we've had a lot of conversations about that recently, but it's not. It's expansive. So even gay, which I think feels simple to most people, especially in litigation. We've been having these conversations from an HR perspective, from a legal perspective for decades, gay marriage, sexual orientation in the workplace. But it's everyone. It's everyone. And so I think that was a little bit of a shock to the system for a lot of people. They didn't expect it to be
I agree with you. I agree with you on Bostock. I wouldn't be surprised to see that. And I'll tell you one that's teed up right behind that. Griggs.
What?
Which one?
What?
Griggs v. Duke Power.
Oh.
What is that? What's that one about?
Spreadsheet discrimination.
What?
Mathematical determination as to whether or not disparate impact occurred, absent of any motive or desire.
Okay. And I was going to ask a question about the LGBTQ, because it does seem like even here in the state of Indiana, we haven't really, there isn't any policy. I mean, because 289, I mean, it does say unlawful discrimination, but I guess the question is, does that even cover LGBTQ plus, community?
The question is going to be, what does sex mean under Title VII, right? I mean, that's the root of that. Yeah. And so, it is the Congress has defined it in the statute, but it's limited to that word. And so, we've relied on the Supreme Court to interpret it for us. And it's very broad right now. But that's probably going to change.
And the reason I brought up Griggs is because Justice Thomas has a giant bone to pick with it.
Griggs. Spell Griggs. It's just
Griggs. Griggs v. Duke Power. What was that, Rachel? 1970.
You said Griggs.
Griggs.
And it's the series of cases that we just talked about that are relying on Griggs.
Yes, exactly. I agree. Griggs is foundational. That was my
prison case.
Okay.
Yeah. And so the prison case.
I think Justice Thomas would.
Okay, Griggs versus Duke Power.
I'm sorry.
Is that Griggs versus Duke Power?
Yeah, Griggs v. Duke Power.
Okay. So just in case there's anybody that wants to listen in, so and I do apologize because today I do have to cut the podcast short, and it is already about to be 4:40. I cannot believe. And we did not get to cover a lot of the topics that we wanted to cover.
Can I go real quick on the so the Republican tax plan is out. Okay. Hasn't been voted on yet. We're a long way from a vote. Everybody's having kittens about the caps on the SALT write-off. So the tax plan includes no tax on tips with cutoffs or caps rather, where the tax benefit would evaporate, right? And there are two legs of that. One is earnings, and the other one is, do you even qualify? So people who make a lot of money would not be able to participate. And so same thing for overtime. Got a cap on that. And then another cap on earnings. So for instance, with overtime.
Chris, I'm actually going to keep it going, but I'm just going to stay off camera.
You got to bounce. That's okay.
So you can explain it. So,
thanks. Basically the way that, and again, this is how I designed it, which I emphasize, this is not anywhere necessarily representative of where the legislation would land, right? So the tax committee has put it forward, and now there's going to be lots of floor debate on it and the whole 9 yards, a lot of moving and hauling back and forth. But it's Speaker Johnson's job to get this across the line. And boy, we haven't even gotten to the Senate yet. So who knows what this thing looks like. But right now, the shape that it's taken is that You would have on, let's see, on overtime, the federal tax would cap out at $10,000 for an individual, $20,000 for a married couple filing jointly. So meaning the first 10K of overtime would not be taxed. Now, it would be taxed for payroll purposes, right? So that you would still collect all the taxes and everything would happen there. This would get resolved when you file taxes in April. So you would then pull all the overtime earnings that you had at $10,000 or less right off your taxable number before any other deduction or anything else. This is a big deal. Comes off the top line, and then you would capture it that way. So it would be captured during tax filing, much like a lot of other programs we have like that. EIDC and all these other things are resolved in final taxes.
Chris, that really gets to the core of the middle class that often feels left out, I think, in these conversations. And, this is really giving them, a branch. Hey, we see you.
I was staggered at the size of it, Rachel. I really was, because that's a lot of money. $10,000 is a lot of money. And clearly, if this passed and you're sitting there and that $10,000, you feel pretty good. You're not even going to earn $10,000 worth of overtime. Right. That's a lot of OT.
Yeah.
For most people. You could just change your W-2 right then and there and just have less money pulled out, confident, right? You know, of what you would be able to write off. But the one that blew me away was no tax on tips, because the way they've written it is it is not limited just like to wait staff or something like that. It's for anybody that gets tipped. Because I was telling Tracy before this program, if they have that, we need to put a tip jar on this podcast.
Well, my son-in-law is a barber, and he just had lunch yesterday, and they made it very clear this applies to everybody in gig work. So Uber, so all those people. So no tax on the tips, and this would be let's see, what was tips? I wrote that down. Tips capped at $25K. Oh my gosh.
$25K for an individual and $50K for a married couple.
So, walk me through this. I mean, that's monumental, but when it relates to the employers, because the impact that's going to have on those individuals is so substantial. For the employers, the FICA is going in. Are the employers getting the credit for that at the end of the day too? I mean, because we're talking about all the tax. What tax?
The article I read didn't get into that nitty gritty. I don't think they are, because it's getting resolved post-employment. So it's getting resolved on the individual's tax return.
So it could only be state and local, right? I mean, there's still
state and local.
Yeah, right. State and local. Okay.
Yeah. The federal tax, state and local could do whatever they wanted, but that absolutely blew me away. Now, the thing that's interesting to me is that the IRS freely admits and has said all along, they have no clue what people are being paid on tips. I mean, it's hard. Sometimes people still leave cash at the table. I still see that people leave cash at the table. But if it's captured on the payment, most people use cards. So if it's captured there, then the employer captures it and they do all that stuff. But just like overtime, it would work the same way. They would be taxed on the tip. So if an employer is just capturing all of that, they would pay the tax on that side. But you're correct. And only on the federal taxation side. So the employee doesn't get to reduce it on the FICA side. So that was an excellent question. I'm glad you asked that. I had nobody brought that up. That's a big deal, because they are already struggling with funding Social Security. I'm very confident that's why that's structured the way it is, because they don't have enough money in the Social Security Trust Fund to carry it past, 2028? I think that was the last actuary. I think that was the last one, 2028, 2029. They moved it back a couple of years.
It changes a lot. I don't know.
It only goes back. I mean, it only gets closer. They don't stretch it out. Yeah. So, so I'm pretty sure that's why they did that. That's a whole nother thing they weren't willing to touch. But
and I'm wondering, I have so many questions, and I'm not a tax guru by any means, but there's conversations about potential for a local income tax to subsidize our unincorporated areas. They have EMS service, and they just don't have the runs to justify the full time. So we're in the city
with that,
yeah. So in the city, we're self-sustaining now completely, but on the outskirts, they're not. So on that local income tax, if they were to implement it, I wonder, how does that work with this legislation? Is it only the state tax that's paid in?
The state and the locals would be left alone in this. Again, this is just on the federal tax side.
Okay. So none of that will. Okay.
Yeah. Now, what's got everybody? They're also trying to do something with Social Security in this, and the way they did this was interesting, because they kind of backdoored it, in my thinking. They're putting in a $4,000 standard deduction if you're 65 or older. That phases out if you have more than $75,000 in non-Social Security retirement income.
Okay.
Yeah,
I think that's great.
Yeah, and so but that originally, remember, the president said, I don't want to tax Social Security. And then I think they looked at the numbers and were like, we can't do that. A lot of people don't know this, but Social Security income does get taxed. If it is your only source of income in retirement, it doesn't get taxed.
Is income threshold, right? I mean,
Correct.
And then at that point, you're okay.
Yeah. So this is why you always see financial tax. You always see financial planners when they're, they want to talk to seniors and stuff like this. They always talk about the importance of what's referred to as a distribution strategy, because everybody thinks about accumulation, shoving money in. You shove money in your 401k, your 403b, your IRA, your Roth. People shove money into that for 20 to 30 years, and they think, okay, I'm just going to pull this out. And you say, well, yeah, but because once your money, if you have $45,000 right now, if you have $45,000 in retirement income that you're pulling out of a pension, or something like that, once you hit that, your Social Security starts getting taxed.
And I think from a kind of a human perspective,
yeah,
those are very often the people who are working part-time jobs because they can't afford their medications.
So what ends up happening, this is why, McDonald's employs a lot of seniors, right? And one of the things that really separates the seniors from the high school kids who are working at McDonald's, the high school kids want to know how many hours they can get, and the seniors tell McDonald's how many they can work.
Sure. Yeah.
Because they can't go over that threshold, because then they're just handing over their paycheck to the feds.
Yep. Yeah.
But again, that's revenue to the government, right? I mean, so when you look at the pay-fors in this, because the other thing they were committed to was this balancing. And I said in the last podcast, to think about, this is near heresy in DC to talk about a balanced budget, because the last one we did was the second half of Bill Clinton's first term was the last time we had a balanced budget in the United States, because Newt Gingrich in the Republican House rammed it through. That was the last time. I didn't
know that.
Yes. Oh, yeah. So we haven't done an actual budget since, I think, the first year of Bush elder. I think right after Reagan. No, we did one under Reagan, and I think one under Bush, and that was it. I mean, just a budget. It didn't balance, but it was a budget. And so we haven't done an actual budget since like 1992. We just do continuing spending resolutions.
And isn't it interesting? I think the difference between national politics, local politics, and even the state level, because
oh, good Lord,
you know,
Indiana does not have a balanced budget amendment, but if any party in Indiana that ever dared to not do a balanced budget would probably lose power for a quarter century.
Yeah, and I mean, even on the local level, I mean,
Yes.
we are ringing the bell. Hey, balanced budget, we're under budget.
Absolutely. No, if this is why you oftentimes hear, especially freshman Republicans, you just see this freshman Republicans because they'll go on Fox and say, we need to run DC like we run our hometown. We balance our stuff. Really, we need to run it like we ran our state. It balances. Yeah. Yeah. You're also not doing the stuff the feds are doing.
Yeah. Well, and when you have that deficit and you're not going to raise taxes, it's a difficult balance.
This is what I'm saying. This is what I'm saying. And so this is why I said, so if you look at how they're making this work. Now, I haven't dug into it, and I'm also not a tax expert also, but I think it's fair to say I'm better than the average bear, but I would not say I'm an expert, right? But just looking at this, the pay for seems to be resting heavily on economic growth, throwing more revenue in, right? Which does tend to work. I mean, generally speaking, when you lower taxes, you do get higher revenue collections because people tend to work harder when they get to keep more. In general, it's not a guaranteed 1-to-1, but I mean, I'm talking just directionally, right? But where they really seem to be putting the weight of this is on the SALT write-off, right? So on
and then what SALT again, Chris?
State and local taxes. So when anybody in Indiana files their Indiana return, if you use tax cut or something like that, use a program, it just automatically does your state taxes. You never see it. But in essence, what happens is you get to write off the taxes you paid to the state off of what you owe to the feds. Okay. So you don't do it twice. So in Indiana, and we're a low tax state, so it isn't that much money, right, that the feds are missing because Indiana is a low tax income state, higher sales tax state.
Yeah, no, I take that deduction every year. So.
Yes, you know what I'm talking about. Okay, so that's referred to as SALT, state and local taxes. So they want to trim that. Okay. Now here's the thing. Politically, this is not a 1-to-1. Again, I'm talking directionally true. In general, most of the states run by the GOP have relatively low or no income tax, like Florida or Texas, just none. And they tend to have higher sales taxes. So they tax consumption, but they don't tax earnings or savings, right? That's their logic, right? You spend what you want, but you're going to pay the taxes. You want to stuff the money in the bank and not spend it, we'll leave you alone. That's kind of like the logic they apply. So as a result, their taxes are lower. And so the write-off that the feds take, the hit that the feds take is lesser. See what I mean? So in Florida, nothing to write off. The feds are clean. They collect every dime that they were going to collect. Now you move to the states controlled by the Democrats. And here I'm talking about California, New Jersey, and New York primarily. Massively high tax states. I'll throw Maryland in there too, because I used to live in Maryland. When I moved from Maryland to Indiana, my pay was actually lower than when I was working in Washington, D.C. When I moved to Bloomington, I made $5,000 less on my salary, but my taxes were 14% less. And so I actually came out $4,000 ahead because I was taxed to death in Maryland. So the same thing happens in those states. So if the feds get absolutely curb stomped by taxpayers in New York, because by the time the federal dollars roll in, they were absorbed by New York State. And so the Republicans will typically say, hey, we're subsidizing those states. They get to tax the daylights out of their citizens, and their citizens would revolt, but for the fact that they get to write everything off on the feds. Now, I don't buy that argument, but nonetheless, that's what you hear, right? And so the way they're doing this is the way we're going to collect this, we're going to limit that SALT. Okay, well, I looked at the limit of the SALT. You know the impact on anybody filing taxes in Indiana? Because
Really?
we have relatively low tax.
Yeah, so it's just not going to be.
Yeah, feds don't give a rip about Indiana. They're losing 3 points, big whoop, right? I mean, and so that's it. But New York, oh my God, I don't know how they get this bill across the line, because every Republican representative in New York, which means the guys upstate, the men and women upstate, right, New York. Mm-hmm. They vote for this, they'll get plastered in the next election.
Yeah, that's a tough position to be in. It's a very, well,
it's a huge ask. And quite frankly, the thing that doesn't make any sense to me politically, you do the math, it's enough to flip the House by itself. Just that. Yep. I mean, because they've got such a narrow majority.
Now, Chris, I'm going to take it back just a little bit when you were talking about the overtime.
Yes.
The tip on the overtime, taxes on the tips and taxes on the overtime. Mm-hmm. Right. Now, does HR professionals have to do anything? Is there anything new that they're going to have to do? No.
Nothing would have to change on payroll. Okay. No, we would be doing our same thing. This is the individual taxpayer's responsibility to write that off. Actually, more accurately, it's up to HR Block to ask that question on the interview. Did you work overtime?
Well, but I do wonder.
Okay, go ahead, Rachel.
I do wonder if, some of the third-party payroll administration companies are going to start adjusting the way the W-2 looks like at the end of the day.
I think they would. Yeah, because where this would really hit, Tracy, from an HR standpoint, because I remember when I worked in manufacturing, we pretty much knew we had an overtime budget, right? We had an overtime budget. We knew what pretty much what we were going to spend, and we had a method of going to people. We had mandatory overtime, although we really tried not hard to pull that trigger. We did everything we could to get volunteers, but occasionally we said, you're up. But we knew that. And in a situation like this, if I were still working for other people and had a plant, I would, from an HR perspective, feel kind of responsible to the manufacturer employees to say, hey, look, this is how much overtime you worked last year. Probably going to work that much this year. It's pretty predictable, right? And let's work together and get your deductions straightened out so you can have a little bit of money in your pocket starting in the next paycheck. I think that's a responsible thing to do.
And do you think like policies, HR policies regarding overtime, whether it's allowed? Do you think that maybe
this is interesting? So I think I could easily see a scenario in which employees who are very reluctant to work overtime might suddenly feel the urge to do.
Of course.
So you might have to flip your policies around to say, hey, if you volunteered, you go to the back of the line, which is usually how I always did with mandatory overtime, right? Mandatory overtime, I always had a policy. If we put the button on you and say, you're going to work, when you did, you went to the bottom of the line. You went to the bottom of the stack and didn't have to get the mandatory, push.
Sounds like a non-union shop, Chris.
Oh yeah.
That's
no,
true.
That's organized labor
layer.
Like the freaking plague.
Oh God,
yeah,
that's another layer to that.
My tenured employees will sleep all day Saturday and make those young kids show up over and over again. They do not care.
Mm-hmm. Yeah.
So
but
so
that's to answer your question.
Okay.
Nothing. ADP doesn't have to change anything.
Okay.
But I do think from HR serving the workforce, I think there is an opportunity there to educate the workers, rather than just keeping quiet and say, that's your business. File taxes at the end of the year. And if you get a big refund, great. I've never been a big believer in giving the feds a dime more than they have to have. I'll write a check every year before I'll ever get a refund. Right. You're the only bank on the planet that will give me those terms. It's incredible terms. They'll let me borrow money and pay them back a year and 90 days later. or 30 day, 90 days later, or conversely, they'll take more from me and then pay me back a year and 90 days later with no interest. No thanks. I'll write you the check. I'm not taking that deal.
It's a pretty terrible savings account.
Pardon me?
It's a terrible savings account scam, isn't it?
It is. I always say that. You need a big return. I'm like, no, you're losing use of cash all year long. Who's lying to you?
My dear clients, Three Rivers Federal Credit Union or Midwest America Federal Credit Union will help you save that money through the year, give you a solid return. So there's
yes. The federal government, don't confuse the federal government with the Christmas Club account. Don't do that.
So I know we're having so much fun.
Yeah.
I know we're having so much fun, but it is 5 o'clock.
Okay, very good.
But we can definitely do this again next month.
Yeah, and I would love, Rachel, if you could make it again, I'd love to have you.
No,
you are adding so much to it. I'm so grateful to have you here.
This was great. Anytime. And so it's fun, and I'm learning a lot from both of you. So that's what it's all about.
Cool.
Yeah, super cool. And so just be on the lookout that we're also going to share information about the in-district campaign coming up here in August. That's a big push, and that's something that we're going to be doing as a state together. So maybe we can even talk about that so people can think about that and how you can start building relationships with your local with the Congress people, congressmen.
Yeah, well, August is when the humidity and the temperature get insufferable. Yes. So Congress goes home for a month. So
and then we jump on and make time to meet with them.
Indeed,
so
we do.
We can definitely talk about that next month. So thank you so much, Rachel, for being for joining us. Definitely tune in next month. And all three of us will be here. And this time, hopefully my computer will be here. So I apologize. So thank you so much, everyone. And bye.
Bye.
Bye-bye.